Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk titled Inheritance and Estate Administration Disputes. My name is Sebastian Liew, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our team today is 28 lawyers strong and a support team of 21. Dato' Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration. We also have a dedicated employment industrial relations team and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. Since the COVID-19 MCO, we moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event it requires specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today, Daphne Rethual and Liew. Allow me to first introduce Daphne. She is an associate in our dispute resolution department. She graduated with a Bachelor of Laws from the University of London. Daphne was admitted to the Malaysian bar in January 2019. Her areas of practice include general litigation, debt recovery, joint management body disputes, probate and administration, and contentious probate litigation. Liew is an associate in our dispute resolution as well as our corporate department. Graduated with a Bachelor of Laws from the University of Manchester. He was called to the Bar of England and Wales in November 2020 and admitted in the High Court of Malaya in 2021. His practice area include non-contentious corporate matters, probate and administration of estate, construction litigation, and corporate and commercial litigation. If you have any questions, please feel free to post your questions in the Q&A box below. Our speakers will respond to them at the end of their presentation at our Q&A session. For today's online talk, we have 4 talk points. Aaron will be speaking first on points 1 and 2, being estate planning and administration and disputes on the enforcement of wills. Daphne will be speaking after, and her talk points will be on points 3 and 4, being disputes on the administration of estate and avoiding and resolving disputes. I will now pass the floor over to our first speaker of the day, Aaron Liew.
Thank you, Sebastian. Good afternoon, everyone. I am Aaron, and as mentioned earlier by Sebastian, today I will be introducing all of you on estate planning and administration and also various disputes on the enforcement of wills. So now, before I begin, what is an estate? Now, an estate is all the assets and liabilities a deceased person had at the point of their death. So an estate can also be categorized into two types. The first one is a testacy, where an individual passed away with a valid will, which takes effect upon the death of the testator. And in intestacies, it happens when a person dies without leaving any will behind. In the case of intestacy, all persons interested in the estate, usually the beneficiaries, can make an application for grant of letter of administration upon the death of the person without a will. The beneficiaries are more set out in Section 6 of the Distribution Act. As you can see in the slides, there are different persons entitled to the estate and the manner of distribution. However, Section 6 covers mostly on spouse, children, and parents as the main persons interested in the event a person died intestate. In the event that nobody else is interested in the estate, for example, none of the family relatives are still alive or nobody's claiming it, the estate will become bona vacantia, which will go back to the government. So this slide is the manner of distribution under Section 6 of the Distribution Act. So it essentially provides you on who are the persons interested, primarily the spouse, parents, and the children. Estate planning, when you have an estate, what you have to do is you need to plan your estate out. For example, you have a lot of assets, property, it can go up to millions, tens of millions, I don't know, any amount. Setting up a plan is very essential to decide who will receive your assets and how your affairs will be managed after you pass away. This usually works out in the form of a will or a trust. However, wills is the more common option in Malaysia because trust is more complicated and requires a lot of formalities. Now, when you have a will, of course, you need to abide a certain formalities to prepare a will. Under the Wills Act 1959, there are certain requirements for a will to be valid. For example, the maker of the will must be of a sound mind, which is something we call the testamentary capacity, which I will address later. And the maker of the will must be an individual of 18 years old or above. And no will shall be valid unless it is in writing and executed in the manner prescribed. Now, in writing and executed in the manner prescribed, what does it mean? This is essentially on what should a will contain. Usually it's the name, the IC number, and also the address of the testator. Who are the executors appointed by the testator to execute their executor duties to distribute the asset? Any contents, for example, the intention or declaration or any wishes that the testator wishes to pass on in the event he or she passed away, and who are the beneficiaries, the date of the will, and also the testator's signature witnessed by who are the witnesses. Now, in a will, like I mentioned, there are usually executors who are appointed to administer the assets and to carry out the wishes of the testator. This executor candidate has to be a willing and capable individual. He or she may be a beneficiary, and in the event that he or she renounces to act or unable to act or perhaps predeceased you, it would be ideal for you to appoint an alternative executor or substitute executor to replace his duty. Now, when it comes to how many appointments of executors, the law clearly stated under Probate and Administration Act that there, at one time, there can only be maximum 4 executors, and the representation cannot be granted to more than 4 persons. We will come to this in detail later shortly when we're doing the case studies and explaining the disputes as administration of estate. Well, in the case that where there is a beneficiary who is an infant or a life interest arises under the will, the administration usually would only be granted to a trust corporation or no less than 2 individuals. Moving on, what can you put inside your will? The Wills Act also provided quite a number of lists of assets and property or interest for you to be disposed by your will. This could include your personal movable property, such as maybe your computer, your car, your furniture, or anything that you deem is of a valuable amount. You can dispose that. Real or immovable properties such as houses, land, condominiums, apartments, or commercial buildings as well. Shareholdings in a company, investments in mutual funds or fixed deposits, or even like any investment brokerage, partnership interest, and also any interest given under the will of another individual. While there is a list provided in the wills for you to in the Wills Act for you to put inside the will, there are things that you cannot dispose of by way of a will. This includes your employee provident fund and also your insurance policies, as both of these, they have their specific nomination form which has already included their nominees inside. Now, when it comes to what you have put in, perhaps you may think that when you're preparing your will, maybe you have already included all your property, known property or assets. But chances are you may have missed some assets or some property that you could have forgotten or you weren't aware of. It could be something like some important documents or some important valuable items in a safe deposit box you have since 20 years ago, or any assets you have acquired after making of the will. This is when residuary clauses come in. It's a very common catch-all provision towards the end of the will, and is to encapsulate all the residual assets which are not mentioned in the will to be distributed subsequently after the clearance of all debts and administration expenses. So Section 8 of the Distribution Act 1958 also provided that without any residuary clause, the estate will become partial in that receipt. Another thing on wills is there is a growing interest in the young adults nowadays that they intend to draft a will even when they're not married, or because life is short, nobody knows what happened the next day. But this will happen when you are not married yet. What happens when you are married? So Section 12 of the Wills Act provides that your will be automatically revoked upon your marriage or remarriage. However, there is an exception where your will expressly provides that you are expecting a marriage. So it is something called a contemplation of marriage clause. It is not common, but then it is something that young adults wanting to draft a will can consider of. Now, we talked about before marriage. What about after marriage or after divorce? Divorce actually do not affect the validity of a will, but perhaps if you want to shift the beneficial interest or beneficial right to some other beneficiaries other than your spouse that you no longer have a relationship with, perhaps a new will is more necessary in such circumstances. After going through the estate administration, estate planning, we come to estate administration. This is what happens after you plan your estate. So estate administration generally splits into grant of probate and a grant of letter of administration. A grant of probate happens where the deceased passed away but has a valid will. The executors appointed in the will have to make an application for grant of probate at the High Court. The process of grant of probate is rather a quick and straightforward one. You just have to provide the necessary documents such as the original will, the death certificate, the IC number of the executors and beneficiaries, and the details of the properties. For grant of letter of administration, it's not a straightforward process or procedure application as compared to grant of probate, because for this one, there's no clear mentioning on who will be the one to apply to the High Court for the grant of letter of administration. This, like I mentioned just now, on when someone died intestate. So this would be someone who's interested under Section 6 of the Distribution Act to apply to the High Court for the grant of LA. So after receiving the application by any person interested, the High Court has the duty to consider all rights of all persons interested in the estate of the deceased, whether any person interested has any objections or they want to file an action to dispute the claim or whatsoever. So the necessary documents for you to claim or apply for the grant of LA is similar with application for grant of probate, but perhaps sometimes you may need to provide further evidence to show that you have an interest in the estate. For example, birth certificate in the event the deceased is your parent, or marriage certificate if in the case your spouse passed away. So in general, this is the length of process that each step has to go. So for a testacy one, grant of probate, straightforward. A will, get executor to apply the High Court grant of probate. Without a will, there's no will there. You have to, any person interested, perhaps the spouse, the parents, the children, apply for the grant of LA, and the High Court will have to determine who it thinks fit to be the administrator, and the administrator would have to provide something called an administration bond, and administration bond to carry out the administrator duty, and then the High Court will grant a grant of LA and a distribution order for any immovable properties like land, houses, etc. So to sum up everything, these are the differences for the estate intestacy and intestacy. So based on this, what I can say is get a will done, plan out your estate to prevent any like delay or long process of waiting or things or disputes, even disputes in the event someone died intestate. I'll move on to my next topic, the disputes on enforcement of wills. While the formalities and the explanation on estate planning and administration have already been covered, it does not mean that your estate is safe and that your wishes will be followed accordingly in the future, that when you pass away. Any will made or any planning made will, of course, still, like any other cases, will still be subjected to possible challenges raised by any parties. But today's top topic, we will cover four of the possible challenges, which they sometimes, in some cases, they apply simultaneously, or some cases they apply separately. But in either way, these are the four major challenges that most of us face most of the time. So the first one is a lack of testamentary capacity, where the testator is not of a sound mind, memory, or understanding. The second one is a suspicious circumstances. The third is an undue influence, and the fourth is a forgery or fraud of the will. The first one is the lack of testamentary capacity. This perhaps comes under heavy fire when it goes to someone who is ill, bedridden, or in a hospital, or perhaps in cancer stage, a last stage of cancer, or like in close to comatose stage, not that fully conscious. Sometimes people will claim that the will was done or executed when the testator was not of sound mind, memory, and understanding. However, in this case, any person who tries to claim that the will is valid bears the burden of proving the testamentary capacity. In the case of Udam Singh against Indak Kaur, the court held that in order to establish a testamentary capacity, satisfy the burden of proof, the content of the will must be read to the testator, and the testator understood the effect and the extent of the disposal of the property. Once this hurdle is satisfied, then the court will proceed to shift the burden of testing something called the testamentary incapacity on the one who alleging the will is invalid or a forged one. In any event, medical report is important if you try to allege or argue that the will was made when the testator is lack of any testamentary capacity. In the case of Lee Ing-chin and others against Gan Yok-shin, it was held by the court that the medical evidence does not support a conclusion that the deceased suffered from unsoundness of mind at any time, in particular at the date of the will. And the court went on further to say that mere bodily ill health or imperfect memory is insufficient to prove testamentary incapacity. So basically from this case, what the court concluded was that what the law primarily looks into is either mental disorder or insane delusion. As long as there's medical report to heavily prove on these points, anyone who alleges a lack of testamentary capacity will satisfy the burden. Now, the next possible challenge is the suspicious circumstances, where these circumstances are the circumstances or situations which make people doubt the validity of the will, or even so, the existence of making of a will. This is sufficiently established in the case of Cheng King Pong against Chong King, where it was mentioned if a will was prepared and executed under circumstances which raised a well-grounded suspicion that the will did not express the mind of the testator, the will is not admissible to probate unless the suspicion is removed by affirmative proof. So a classic instance to demonstrate this is when there's a substantial gift to a person who prepared or was closely involved in the preparation of the will. This is something that perhaps where there is a beneficiary who has more than half a share of the estate or has comparatively to other beneficiaries, which other beneficiaries will think is unfair to them. To counter that, one method of dispelling the suspicious circumstances is to show that the testator has actually obtained an independent legal advice. This was reaffirmed in a recent case of Adam Sofyan bin Abdullah, which was reported last year. The next possible challenge is an undue influence, where the person's alleging undue influence, of course, bears the burden of proving. It could be something like influencing heavily or like coercing, forcing, threatening the testator to make a will based or like in the form it had taken. For example, you draft a will and then forcing the testator to sign it. So the will was not a voluntary act of testator. So for example, the testator did not want a will to begin with. This was found in the case of Carmel Mary Susse, where the court held that there are elements of coercion and pressure. It was not a voluntary act. For example, forcing the testator to sign the will. And last but not least, the last possible challenges, or perhaps one of the most common one, is alleging of the will was forged or it was a fraudulent, it was made out of fraud. This perhaps is one of the most common one because most people will usually argue that the testator's signature on the will is not the true one or the genuine signature, and it's a forged signature by someone else who's interested in the will. This allegation of forgery is most commonly raised in a situation where there are two wills in existence. For example, in the case of Cheng King Pong, there are two wills, and the court held that the second will is a forged one, as the signature was most probably not under the same authorship. In order to show that there is an element of forgery, evidence of handwriting experts to prove the signature is very important. This was held in the case of Dr. Shanmuganathan Federal Court Appeal case, where the Federal Court allowed the appeal that the trial judge had overlooked or failed to take into consideration the evidence of the handwriting expert when comparing the signature on the will with the other 20 signatures of the deceased, and had concluded that the will was a forged will. So there goes my sharing for today. Thank you everyone for your attention. I will now pass the floor over to Daphne to speak on other disputes on administration of estate and how to avoid and resolve disputes by going through some case studies with us. Over to you, Daphne.
Hi everyone, I'm Daphne. Thank you for joining us today. I'm going to start my presentation touching a little bit on disputes on administration of estates. What are the common disputes revolving administration of estates? Sometimes in administration of estates, there might be issues of breach of trust by the executor or the administrator, where the executor or the administrator might be acting in their own self-interest, or they might misappropriate the funds belonging to the estate, or where there's a conflict of interest where the executor buys the estate's property at probably a lower price or something. And then also there could be a failure or refusal to distribute assets or to provide estate accounts. Estate accounts are really important because it will show how the funds belonging to the estate are managed and whether it's been mismanaged. Can an executor or an administrator be removed yes, the answer is yes. The court is empowered to remove an executor or trustee where there is a failure to act. Generally, the primary consideration for the court is the interest of the beneficiaries and the estate to be protected. The High Court has generally revoked a grant of probate and letters of administration in situations where there's a serious misconduct committed by the executor, trustee, or administrator, or where the relationship between parties has deteriorated to the extent where administration can no longer be effectively carried out. Say maybe the executor and the beneficiaries are not on good terms. It's quite difficult for the executor to actually administer and to carry out the wishes of the testator. Sometimes the High Court has also revoked grants where probate or LA has been obtained by misrepresentation or fraud. However, especially where there's a will, the court is generally very reluctant and slow in removing the executor. There is actually no direct provision under written laws for the removal of an executor or administrator, but the closest we can find is Section 40 of the Probate and Administration Act, where it says the court shall have power to summon any person to prove or renounce probate of the will. Section 34 of the Probate and Administration Act also says any probate or letters of administration may be revoked or amended for any sufficient cause. Sufficient cause is generally the so-called test for removal of an administrator or executor. Executors or administrators can be removed. These are a few examples of how they can be removed. For example, failure to render accounts, administer, to call in assets where they have intermeddled with the assets, or where there's an active hostility towards the beneficiaries. The phrase sufficient cause is not defined, but it's taken on a case-to-case basis. It's an objective test where the paramount consideration is the welfare and interest of the beneficiaries. In the case of Khu, the court actually said that Section 34 of the Act empowers the court to interfere if sufficient cause is shown. The phrase sufficient cause is not defined, but the courts have always considered the welfare and interest of the beneficiaries of an estate as the paramount criterion in deciding whether or not there is sufficient cause to interfere. It is strictly an objective test. In the case of Liga Fernandez, the court has said all that is needed is for the plaintiff to adduce sufficient evidence to raise a strong suspicion of the defendant being the executor or the administrator, the defendant's inaction, want of diligence and honesty, or a conflict of interest situation or inability to act for the court to actually decide to interfere. There's also one other situation where an executor is removed without a misconduct per se, is where there are more than 4 executors named in the will. So what Aaron mentioned earlier, under the Probate Administration Act, there can only be 4 executors named under a will. So in the case of Moy Yok Lai, there was actually 5 executors named. The court decided to remove the 5th executor name. Can an executor renounce his or her executorship if named under a will? So yes, Section 8 allows the executor to expressly renounce by way of court papers, where by way of court cause papers, you can actually file in an affidavit and say you would like to renounce your executorship for whatever reason. Maybe you're migrating and it's not entirely convenient for you to come back and manage the affairs of the estate. Constructive renunciation is where, on the issue of citation, I'll touch a little bit later, but constructive renunciation is where the beneficiaries or the beneficiary of the estate has brought an action and then to so-called send a notice to the named executor to come to court to say whether he or she wants to administer the estate. And if the executor does not turn up in court or does not respond, he or she is deemed to have constructively renounced his executorship. So once you have renounced your executorship or administrator, you can no longer apply for representation. There's also something called an administration action. An administration action is an action you file in court when there's a dispute between you and the executor or administrator. So the purpose of an administration action is to obtain directions from court on certain questions that arose during the administration. It could be, how do we distribute this, whether it should be done now or later, where there's certain uncertainties in the affairs of the estate. You can apply to court to clarify these issues. The procedure is provided for under Order 80 of the Rules of Court. So these are some of the issues where you can deal with in an administration action. Any question arising in the administration of the estate, or any questions as to the composition of any class of person having a claim against the estate or a beneficial interest in the estate, or when the rights or interest of a person claiming to be a creditor or claiming to be entitled under a will or on the intestacy of a deceased, where there's an issue arising, you can also apply for an administration action. Caveat, in respect of caveats, this is not the same caveat we talk about in land matters. So in land matters, you will file caveat over a land so that people can't sell the land. But this caveat is in respect of estates of a deceased person. So let's say for a fact that someone has a copy of the will, but then that's not a will, that's a forged will. But there's a possibility that the person might apply to court to obtain probate. So what you can do is to lodge a caveat in court under Order 71 of the Rules of Court. So you file a caveat. It's basically a notice to court saying that please don't grant any probate or letters of administration in the meantime. The caveat is valid for 6 months. So once a caveat is in place, the court will not grant any probate or letters of administration until it has heard all parties. A citation is a notice issued when the executor in a will delays or declines to apply for a grant of probate. So what I mentioned, the beneficiaries could apply for a citation and then to get the executor to come to court to say that whether he or she actually wants to administer the estate. If not, then the court will have to appoint another executor. And then citation can also be issued to propound a will where some parties actually doubt that the will is valid. Okay, so where a person generally believes that a will has not been proved or is invalid, he can issue a citation for the executors to come and prove that a will is valid. So generally, these are the types of reliefs that we can ask from court in respect of administration of an estate. You can ask for an order to verify accounts, to direct a person to do something or not to do something in his capacity as an executor or administrator, or an order approving the sale of a land. If it's intestacy, the administrator will have to get order to sell the land. And then also an order directing any act to be done. So if you suspect that your executor is not doing anything, you can get a order for the executor to start doing his job as an executor within the next 1 month or next 6 months, failing which, if he still doesn't, then perhaps the next thing to do would be to apply to remove him. So we've prepared a few cases just to show circumstances where the courts were happy to remove executor or administrators. So in the case of Mak Chi Chong and Rob Wills, in this case, Rob Wills was the named executor under a will, but the court removed them as the executor on the grounds that so this case, the estate involved was in East Malaysia. So Rob Wills is actually based in West Malaysia. And nothing is stopping the testator from naming Rob Wills, but then the grounds where the court stated in removing Rob Wills as an executor is that Rob Wills is out of the colony as they want to oversee the sale of a land or negotiate for a sale of a land. The representative of Rob Wills has to fly over to East Malaysia. So this would incur unnecessary costs and might deplete the estate quicker than expected. And then also in that case, the executor was unwilling to fork out their own funds to apply for probate first. So the argument was the particular estate did not have funds deposited with them for them to start any action. So in this case, the applicant to remove Rob Wills was the lawful husband of the deceased and the father of the two beneficiaries. Under the will, the lady actually named two of her sons as the only two beneficiaries. So the father applied to take over administration of the estate. Here, the court said, in my view, while the wishes of the deceased may be absolute and sacrosanct in respect of the distribution of the estate, it is not absolute in the matter of administration of the estate. It must necessarily depend on the exigencies of the prevailing situation and interests of the beneficiaries. Otherwise, the law would not have empowered the court to remove the executor for sufficient cause. So really, there's no point keeping Rob Wills there if just by virtue of them flying over would deplete the estate. What is the point of having an executor? Next case is Rachel Mei-Ling Ong, another, and Dato Bruno Henry. So the defendant here is the executor. Here also, the court removed the executor because the executor did not provide accounts of the estate. So the court said, surely the plaintiffs are entitled to be kept informed, at least by way of a monthly statement as to the state of affairs of the estate. The defendant could have at least sent the plaintiffs a copy of the bank statement each month if he was unable to send proper audited accounts earlier. And in this case, the executor also charged a fee of 300,000 to administer the estate, which the court thought was exorbitant. So in this will, the deceased had left his entire estate to the plaintiffs in equal shares, and it was clear that he intended the trust, there was a trust under this will. He intended the trust to cease upon the beneficiaries attaining the age of majority. At the point of the application to remove the executor, both the plaintiffs, being the beneficiary under the will, were already above the age of majority. And the court said, in view of the hostility between the parties, the trust was ordered to cease. We also have this more recent case, Daljinder Singh and Amardeep Singh. Here, the court removed the defendant as an executor on the grounds that sufficient cause was established for his failure to distribute the assets until the date of the decision. The administrator, Amardeep Singh, was appointed as the administrator of the estate on 18th of November 2016. But until the date of decision, probably somewhere in 2021 or 2022, there was still nothing done to distribute the assets. So the court viewed this as tardiness and lack of progress. And also in this case, the administrator was involved in several transactions to misappropriate the funds belonging to the estate. He actually transacted with himself substantial amounts in sum of about 200,000 and to third parties and in about 700,000 ringgit. And he also awarded himself a salary of 60,000 a year for doing nothing. But then the defendant actually just attempted to justify his delay in his failure to distribute assets on grounds of 19 pandemic, but the court said, no, it's not an acceptable excuse because he was appointed way before MCO. In this case, the person applying to be substituted as an administrator is actually a foreigner, but the court said just because he's not a citizen, he is not precluded from applying to become an administrator. So the court removed the administrator and the executor and replaced him. So avoiding and resolving disputes. How do we avoid and resolve estate disputes? First of all, prepare a will. Make sure your will is as explicit as possible. Set out all your assets so that your executor and your beneficiaries don't have to go and hunt for your assets. Yeah, prepare a will, be as detailed as you can, that would reduce the risk. I'm not saying that it would entirely diminish all risk of estate disputes, but it would help. If everything has been done and now you're caught in a situation where there's a dispute between administrator, executors, and beneficiaries, have a discussion, sit down, try your best, have a sit down between administrator, executors, and beneficiaries, because from the cases we see, most of these issues are between family members. So sometimes when we do cases, we feel like, you guys are related, why don't you all just try to sort it out? So it gets a bit sad when family members can't actually sit down and have a cordial conversation. So yeah, try to sit down and sort it out. Of course, if it's a lost cause, then you have to go to court. But yeah, I try to avoid that. And then as beneficiaries, perhaps it would be helpful to request for an update for all the estate's affairs periodically, like estate accounts, distribution of assets, dividends accrued from shares or rental income. And if you are the administrator and the executor, it would be advisable for you to provide regular updates to your beneficiaries to avoid them from thinking you are sitting on your job or you are misappropriating the funds. Yeah, I think that's all my presentation. I will hand back to Sebastian.
Thank you, Aaron and Daphne, for your insightful presentation. We will now begin the Q&A portion of the session. The first question we have is, I will direct it to Daphne. If there is a will and the administrator is also a beneficiary, but there is a dispute, who is able to administer or solve the dispute?
If there is a will, of course, the administration has to follow the will as closely as possible. If there's some uncertainties or some dispute, I mentioned earlier, you can apply for an administration action to clarify the uncertainties.
For the second question, I'll direct it to Mr. Aaron Liew. What's the stamp duty payable for real estate assets to be transferred following the will? What about listed securities of public companies?
Basically, for stamp duty, usually what the legislation that applies here is the Stamp Act 1949. So in this case where there is a transfer of the real estate assets following the will and also the grant of probate, I think it could be under item 32I of Schedule 1 of the Stamp Act. And the stamp duty for the transfer of the property to the beneficiary, regardless of whether there is a will or not, no will is 10 ringgit, because there's no real property gain from there, like for example, selling or disposing the property to someone else. But for the listed securities of public companies, my understanding is if, for example, this is something securities that you have purchased or deposited with a CDS account, which has a license with Bursa Malaysia, perhaps what you can do is to get the grant of probate or like any relevant documents to show that you want the assets to another account. But as for the stamp duty on listed securities wise, I'm not too sure on how they calculate that, because the LHDN is have a lot of discretion in determining how to calculate the stamp charges.
So for our third question, I will direct it to Daphne. Who are normally the witnesses to the will? Can the beneficiaries be the witnesses to the will?
Thanks, Sebastian. The witnesses to the will can be anybody of above 18 and capable of witnessing a document. When we prepare wills, we get our fellow lawyers to witness a will. So no issues. Beneficiaries cannot witness a will. Even spouses to the witnesses cannot be beneficiaries. If you're a witness to the will and you're also named as a beneficiary, it would be an invalid gift. And if your spouse is named as a beneficiary and you witness the will, it would be invalid as well.
Nice one, Daphne. And the next one will be to Aaron again. In an LA application, must all the beneficiaries under Section 6 agree to the appointment of the administration? And must all be present for hearing?
Thank you, Sebastian. For this question, in some cases, most of the beneficiaries, for example, the spouse or the children or parents, they usually what they will do is they come to a mutual consensus. They agree, they put forward, they come to a family meeting to discuss everything and agree that, okay, we'll let this, for example, this eldest son to go to apply for the grant of LA. So everyone else agree. So I think usually it could be verbal, it could be written, but if it involves a big estate or like you may foresee there are some family disputes or any large major disputes coming out from the estate, I think there could be some sort of a written agreement or like a deed to be in place to state that all the purported persons interested come together to agree to appoint someone in the family to be the administrator to apply for the grant of LA. And for the second half of the question, not necessary. Usually it would be the applicant for the grant of LA application will attend the hearing. But of course, this is subject to different courts and to see whether they want to see the applicant or not.
Thank you, Aaron. Good ones. The next question is to Daphne. Who verifies the executor follows the wishes of the testator as per the will?
Honestly, nobody. That's why sometimes it's good for you to leave hints that you are leaving a will behind so that your beneficiaries actually know. Nobody actually monitors the executor. That's why when things get ugly, the only way is to go to court. That's how they actually try to rectify the whole situation, by removing the executor or to get the court to make a specific order for the executor to carry out the clauses of a will.
Wonderful. Next, we have Aaron again. What will happen if the beneficiaries proceed to apply for a grant of a letter of administration without realizing that the deceased made a will? And is the High Court able to trace the deceased will? Aaron?
Thanks, Sebastian. For this one, actually, it can be a little bit tricky because sometimes our family members made a will and none of us actually was made aware of that or things like that. But however, the High Court would not be able to really trace the will per se because it's not an official document to lodge in the High Court when someone made the will. It's something that kept private and confidential or more personal to the testator itself. or in some cases, perhaps deposited in the legal firm that was made, that drafted and prepared the will. But of course, in any event, if you think there might be a will in place and you couldn't find it, you need some time to probably trace it back. But then maybe you're also in an urgent situation to apply for a grant of LA to distribute all the assets. Perhaps under Section 18 of the Probate and Administration Act, the court may actually grant you a grant of letter of administration, but it's limited until or when you can provide or show a copy of the original will when you found out the will to the court. So basically, grant of the LA is still doable, but if you think there is an existence of a will but you couldn't find it, so perhaps the safest method at that moment is to file a grant of LA application.
Thank you, Aaron. We are running out of time, so I think I will direct one last question to Daphne. The question is, can a law firm be appointed as an executor?
Yes, but perhaps one particular lawyer might have to be named as the executor. Yep, that's all.
Thank you, Daphne and Aaron, for your insights. Before we conclude, I have a few announcements to make. Please join us again for our upcoming talk. On the 28th of September, we have a talk on what to know if you are stopped for drink driving and other road traffic offences. The speakers are Vivian Fan and Wong Chien. On the 5th of October, we have an introduction of torts of trespass and nuisance. The speakers are Vivian Fan and Eric To. On the 19th of October, 2022, forced resignation versus constructive dismissal. The speakers are Carolyn Ng and Naveen Joshua Solomon. Please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Do follow or like our social media accounts. We have accounts on YouTube, Twitter, Instagram, LinkedIn, and Facebook. If you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us. We hope you found today's session informative and useful. Thank you, everybody, and see you in our next talk.